I expressly do not consent to this court's jurisdiction and do not.
Well, then
Any
you are
rights.
not a named party, so if you're not consenting to this.
This right here is Sovereign Citizen 101. Walk into court, reject its authority, and then still try to argue your case. Spoiler, that never ends well. Judges hear this nonsense constantly, and it always backfires. But do you think she actually believes this script works, or is she just stalling for time?
Court's jurisdiction, sit down.
Oh,
You can go.
oh, I see. So I need to,
I don't know what you need to do, but
well, let me respond.
to what? You're not consenting to the jurisdiction of this court. Why am I hearing from you?
I'm recanting
You're recanting what?
what I just stated.
Which part?
The part that I lost my spot. Oh,
Well, no, it doesn't work that way.
okay, I'm not really understanding, but I am nervous, quite nervous.
Ian Redmond, P70599, on behalf of the plaintiff.
And your name, ma'am?
Doshia Banks occupant.
Pardon?
Doshia Banks occupant.
Doshia Banks occupant, Your Honor.
Okay. So you're not Miss Whitlow?
No.
So what is your position in this case as you see it?
If I may, Your Honor.
Okay, good. Go ahead.
Ms. Banks claims to be an occupant of the property. She filed a bankruptcy case listing the property as hers. The bankruptcy stay was lifted, which gave rise to our motion to reopen the case. The order lifting stay I would like to present to the court because it has some interesting language in it, Your Honor, which includes, it is further ordered that the bankruptcy court finding this filing of this petition was part of a scheme to delay, hinder, and defraud VMC REO LLC. Additionally, Your Honor, the bankruptcy court ordered, let me see, notwithstanding Rule 4001A3, a bankruptcy rule,
Right.
creditor VMC REO LLC may execute on its order immediately.
That's the smoking gun. When a bankruptcy judge outright says your filing was a scheme to delay and defraud, you're cooked. Bankruptcy court doesn't throw around that kind of language lightly. Translation: she wasn't just broke, she was playing dirty. And once that's on record, every other judge down the line already knows what kind of game you're running.
The order shall be binding and effective despite any conversion of this bankruptcy case to a case under any other chapter of Title 11 of the United States Bankruptcy Code. Further, that the recording with the appropriate governmental entity of this order shall constitute a bar to refiling any case under any chapter of Title 11 of the United States Code as to the property located at 5779 Pinecrest Estates Drive, Ann Arbor, Michigan. Wow. The property in this case. A debtor in subsequent case under this title may move from relief from this order based upon a change of circumstances or for good cause shown after notice and hearing. Said bar shall be for 2 years from the entry of this order or until such time creditor relinquishes their rights to the property. This order came out June 24th of this year. I have a copy for you. I will note, Your Honor, that Ms. Banks has filed an appeal of that order in the Federal Eastern District of Michigan. That appeal is pending, but the status quo as of right now is that there is no stay, and that order lifting stay holds until such time as the appellate court does something. Additionally, Your Honor, there is no stay from the appellate court. They have not issued a stay, and in fact, it would be appropriate that there would be a bond placed or an escrow order of some sort, because BMC has been the owner of this property for the past year and does not have access to it. Additionally, Your Honor,
There's more. Go ahead.
there's a lot going on.
Yeah.
Additionally, Your Honor, Ms. Whitlow, who as far as I know, actually exists, but I don't have any evidence to that effect. Has not appeared in any hearings in this court, did not appear for her deposition that she was noticed for in the federal case, and in a federal case, the federal court issued a show cause order to Ms. Whitlow that she had to present certain documents from this court, which she failed to do. Her deadline to do so was, I believe, July 3rd. Let me confirm that. Oh no, July 10th. And she did not supply any of those documents. I can present that show cause order if you would like.
I don't know that I need that because
Okay.
I'm not.
The reason that I mention all of this, Your Honor,
Go ahead.
is that this is $1 million house in Ann Arbor that Ms. Whitlow purchased with a mortgage and less than a year later defaulted. The foreclosure went through, the sale occurred, the redemption period expired, and we came forward to evict. Since then, there have been multiple bankruptcies. Ms. Whitlow filed 2 different bankruptcy cases. A young man who apparently lives in Arizona filed a bankruptcy case and listed this property as his residence. Ms. Banks has filed a bankruptcy case and listed the property as her residence. It should also be noted that Ms. Banks was a bankruptcy preparer and has been forbidden from the bankruptcy court from preparing bankruptcies for anyone other than herself.
This case is a straight up fraud, and it's just the way she thought it would all work tells you everything. And I'm just assuming here, but I think she pretended to be the Whitlows, got a mortgage on a $1 million home, defaulted on it, and then turned around and tried to use bankruptcy to keep the house as if she had any legal claim.
Exactly. The play here is abusing bankruptcy's automatic stay, which freezes collections and evictions. But when you file multiple bogus cases, judges see the pattern instantly. It's basically legal whack-a-mole, and every time she files, her credibility sinks deeper. So here's my question. Should people who abuse bankruptcy like this face criminal fraud charges, or just eviction?
The only problem here, she's not even on the mortgage. I mean, that's like borrowing your neighbor's car, crashing it, and then filing insurance in their name. It just makes no sense here, and it's obviously fraud. What blows my mind is how she thought she could pull this off without leaving a paper trail. I mean, mortgages and bankruptcy filings leave records stacked a mile high, and once investigators start piecing it together, the fraud sticks out like neon lights. I mean, it's really not too hard to see. I mean, judges too, they don't just look at whether you said the magic words. They look at whether you had a legal right in the first place. And here, she literally has nothing. She just stacked lie on top of lie, thinking she could just overwhelm the system with nonsense paperwork. I mean, do you guys think she has any clue how bad this looks on paper? Or is she too far gone in the sovereign citizen mindset to even care? Because if she keeps pushing this, prison is not off the table.
I list all of these things to show that the scheme continues. And that's why we would like to reopen this case, because there is no stay in place. We would like to move forward with an immediate eviction, at most an 11-day vacate. And if for some reason that would not be amenable to the court, we would ask for an escrow order or a bond. On $1 million property, I think it would be reasonable that $10,000 a month rent would be reasonable.
All right. Thank you. Ma'am,
Yes, Your Honor?
what do you want to tell the court?
Well, just for 60 seconds, and then I wrote something up because I am nervous, quite nervous. But I, Doshia Banks, is respectfully appear, specially and conditionally, for the sole purpose of protecting federally vested occupancy rights and opposing unlawful state action. I expressly do not consent to this court's jurisdiction and do not.
Well, then
Any rights.
you are not a named party. So if you're not consenting to this court's jurisdiction, sit down.
Oh,
You can go because you're not a named party.
I have a lease.
You are not a named party on this. You may have a lease with someone else, and
No,
then
I have
you
a
can
lease
go
with-
challenge it. With who?
With Whitlow. Ms.
Then
Whitlow, who
you
is
need to
supposed-
go against Miss Whitlow.
Pardon me?
Then you may need to go against Miss Whitlow. But if you're not consenting to the jurisdiction of this court, you might as well just sit down. You are not a named party. I do not have to hear from you.
Oh, I see. So I need to,
I don't know what you need to do, but
well, let me respond.
to what? You're not consenting to the jurisdiction of this court. Why am I hearing from you?
I'm recanting
You're recanting what?
what I just stated.
Which part?
The part that I stated that I'm not